हेलो फ्रेंड्स। आज हम पढ़ने वाले हैं टॉपिक सरफेसी एक्ट 2002। दिस एक्ट केम ऑन 21st June 2002. The financial sector has been one of the lay handlers in India efforts to achieve success in rapidly developing its economy. Since our existing legal framework relating to commercial transactions has not kept pace with the changing commercial practices and financial sector reforms. This ensures the slow pace of recovery by defaulting loans and escalating levels of non performing assets of banks and financial institutions. In the Narasimha Committee, first and second, and Andhyayarunya Committee was constituted by the central government for the purpose of examining banking sector reforms, have considered the need for change in the legal system in respect of these areas. Now, we just going to discuss the applicability of Sarfaesi Act 2002. Before we come on the applicability, we should know that the Sarfaesi Act is also apply on Jammu and Kashmir. The applicability of the Sarfaesi Act 2002. The amendments of this act is an act to regulate securitization and reconstruction of financial assets and enforcement of security interest and to provide for the central database of security interest created on property rights and for matters connected there with or incidental thereto. Apply all over India, Jammu and Kashmir. Lender should be a bank or public financial institution. Now we come on the role of Sarfaesi Act 2002. The first and most important role of the Sarfaesi Act was the securitization of financial assets and issue of security receipt. As we should also know the full form of the Sarfaesi Act, as Sarfaesi Act full form is securitization and reconstruction of financial asset and enforcement of security interest. As the first important, the securitization of financial assets and issue of security receipt. It acquire financial asset by issuing debentures or bonds or by agreement. Release the same and redeem the security receipt issue to the QBs. Reconstruction of financial asset means take measure for proper management, sale, debt, reconstructing settlement or to take possession subject to RBI guidelines from time to time. Third one is enforcement of security interest. Enforce security interest by the secured creditors without the intervention of the court. And the fourth and the last one, the other functions. That means the other function of this act and the other role of this act as the act as an agent of banks or financial institutions for recovery, act as a manager of the secured asset appointed by the lender, or act as receiver appointed by the court. Now we come on the objectives of the Sarfaesi Act. Efficient or rapid recovery of non performing assets of the bank and financial institutions. And the second one is allow bank and financial institution to auction properties when borrower fail to repay their loan, as they have the right to sell the property of the borrower when the borrower will not be able to pay off the loan, as the property here is a kind of asset to the bank. The process to be followed by this in the Sarfaesi Act, as there is a borrower, the borrower provides security to the bank, and the bank gives the property secured assets transfer to the asset construction company, and the asset restriction company will give the security receipt to the qualified buyer, and in the case then the qualified buyer will give the cash to the asset reconstruction company, and the asset reconstruction company gives the cash to the bank or the financial institution who is the originator, and in the return to the borrower they will get the financial assistance. Now we are coming on the formation of Sarfaesi Act 2002. As the Sarfaesi Act was circulated to regulate securitization and reconstruction of financial assets, reinforcement of the security interest for matters connected therewith or incidental thereto. It extended to the whole of India. Amendment in the Sarfaesi Act 2002 widened the enforcement of the security interest and recovery of debt laws and miscellaneous provisions, and is amended in the year 2016. The enforcement of security interest and recovery of debt laws and miscellaneous provisional information in the official gazette as it is amended in 2016 was published. Now we are doing some main sections of the Sarfaesi Act. It's not important to remember all the sections in the Sarfaesi Act. The section 1 deals with it applies wholes of India including Jammu and Kashmir. Act is the main point that not all the acts apply to the Jammu and Kashmir, but some of the acts apply to the Jammu and Kashmir. So it's very important to remember that Sarfaesi Act will apply in the Jammu and Kashmir. It came into force on the 21st day of June 2002. Section 2 deals with the definition, as all the acts deals with the definition only in the section 2. Now the B part, the section 2 subsection B deals with the asset reconstruction. So here it will become easy to remember by a flow chart. The flow chart makes your understanding better. Borrower gives the financial assistance to the bank, and the bank will give the asset to the securitization company and reconstruction company, and in return bank will give the secured asset to the borrower. Bank provide financial assistance to the borrower. Borrower give or provide secured asset to bank. Bank will contact securitization company, reconstruction company and SVP, and SVP stands for special purpose vehicle. Then bank will give or transfer the secured asset to the securitization company or the reconstruction company. Now we will come on the definition of borrower. Borrower definition is also very important. Now we come to the section 2 subclause subsection J. It deals with the default. The default means when the person is not able to pay the amount, and the amount will goes to the principal plus interest is equal to default. It means non-payment of principal and interest, as the person is not able to pay the amount back to the bank, the financial institution. And the second means the payable by borrower to lender or the bank. to the extent that it is to be declared NPA in books of lender declared as by the RBI guidelines. The guidelines will be given by the RBI non-profit asset. Now we will come on the modes of recovery of debts. The recovery officer shall, on receipt of the copy of the certificate, shall, subsection 7 of section 11, proceed to recover the amount of debt specified in the by one or more of the following modes. Now we come with the attachment and sale of the movable or immovable property of the defendant, arrest of the defendant and his detention in person, appointment of the receiver for the management of the non-movable and immovable property of the defendant. The objectives are of the debt: speedily recovery of debt which is due to any person and the loan given by banks and financial institutions. The act was made to help the banks and financial institutions. Mainly, the courts was there to help out, but according to the economy, it was not preferable. In the civil courts, there are pile of cases who are still in the court, so it's very difficult for the courts to handle these matters as well. The DRT is the only place where only the banks and financial institutions, that is debt. There are 33 DRTs only banks can apply, and there are 5 DRTs, and the full form of the DRT is Debt Recovery Appellate Tribunal. There are 3 DRTs in Delhi in 1994 DRT established. If you are not satisfied by the DRT, then you can go ahead for DRAT, as if you are not satisfied with the jurisdiction or the decision of the district court, so we can file an appeal in the high court. Same as in this, bank or the party both can apply, anyone can apply. DRT created by special tribunals by central government, and the composition is very important. It constitutes one person, should be a presidency officer, and the 2 are the recovery officer. And the qualification of these should be a district judge or session judge, 5-year or 65, whichever is earlier. No judicial background required. Doing work for presidency officer direction. Now we come on to order passed by recovery officer, and against of the order you can apply by presidency officer. So as a presiding officer is further divided into 3 parts, as basically presiding officer, other officer, and 2 recovery officer. Under the presiding officer, as there is need of judicial background, but in the other officer and 2 recovery officer, there is no need of having a judicial background. Judicial background, but judicial order can be passed by recovery officer. Under the section 2 of subclause G, the definition of the debt which is given, it means any liability inclusive of interest. The debt is equal to principal plus interest. Now if the debt is less than 10 lakh, then DRT provision shall not apply. If debt due is equal to principal plus amount, the Supreme Court decision regarding the DRTs are there are two jurisdiction: original jurisdiction and appellate jurisdiction. Original jurisdiction is 10 lakh or more than 10 lakhs, and the appellate jurisdiction which is less than 10 lakhs. DRT is basically for 10 lakhs, and the Sarfaesi Act which is basically deals with the amount of less than 10 lakhs. So banks can ground the Sarfaesi Act. Now, if we come to the constitution validity, so there's a case, as the notes are not given, so you can just write down. In the Supreme Court case, the Mardia Chemicals Limited versus Union of India has decided that the Sarfaesi Act had the constitution validity. Had decision proven by the Supreme Court in the case Mardia Chemicals Limited versus Union of India. Now we come to the next case law, which is Signal Apparels Private Limited versus Canara Bank. I will also repeat again. Signal Apparels Private Limited versus Canara Bank. Guidelines issued by RBI in relation to classifying NPA should be followed by the bank before issuing notice under Section 13 Subclause 2 of the Sarfaesi Act. The judgment discussed at length in the meaning of NPA, its ambit, scope, and the writ petition dismissed. In the second case, Mahavir Plantation Private Limited versus KK Steel. Demand notice to guarantor mandatory. Notice to guarantor under Sarfaesi Act is mandatory. Proceedings without such notice will be violated. As is also happens same in the case of Enterprises versus ICICI Bank Limited. Now we discuss the next case law, which is Youth, and the spelling of the Youth is YUTH. Development Cooperative Bank Limited, Kolhapur versus Balasaheb Dinakarao Salokhe versus and others. It is a bar of jurisdiction of civil courts. Civil courts has no jurisdiction to entertain any suit filed in respect of action taken under Sarfaesi Act. I will again repeat the case law name is Youth Development Cooperative Bank Limited, Kolhapur versus Balasaheb Dinakharo Salokhe and others. Now we discuss the other case law, Noble Aqua Private Limited versus State Bank of India, and the other case law is Sarfaesi Act, Sarfaesi versus SICA, SICA. The jurisdiction of both the cases are same, that is the provision of Sarfaesi Act overrides Section 22 of SICA. The conclusion of the Sarfaesi Act, as we will put the notes in a nutshell. So if we know the importance of the conclusion, then maybe you will understand the topic very well. You can write down the conclusion. It will be very helpful for you to gain good marks in your exams. The high level of NPAs has led to lower interest income and loan loss provisioning requirement, which reduce the profitability of the banks. The act is intended to strengthen bank and financial institution to recover NPAs faster. The act empowers bank and financial institution to seize charged assets without court intervention and sell them off. As the last, I want to just say that Sarfaesi Act is such a wide act, and it's a little bit confusing. So, according to me, just go through the notes very well, and later on you will understand, because these notes are the crux of the Sarfaesi Act. Maybe you like it. If you like it, so please like and hit the bell icon, and please subscribe my channel. Thank you.